Chairman, sir. Sir, when the word India is used instead of New Delhi, sir, we have no objection for this bill. Sir, no doubt we have a very competent law minister, but the draftman is not competent. Had he used this word, India, in 2019, it would have not made us to sit here and discuss and to pass this bill only for the purpose of substituting the word New Delhi with that of word India. Sir, it cost around rupees 2.5 lakhs per minute to the exchequer for running a parliament for a minute. If we calculate for both Lok Sabha and Rajya Sabha, the combined expenditure of the exchequer for the present bill would be 1.5 crore. Due to the incompetent draftmen, so much money is being wasted. That is why I am asking for such competent draftmen along with an editorial board to understand the needs of the bill and its long-term ramifications. Before tabling any bill before the Parliament, the stakeholders should be consulted. The legislative impact assessment should also be done. So that is how the participation of all will be there in bringing out a bill. Sir, there is an emergent need to reconsider our arbitration laws as they are becoming detrimental for government contracts. I am sorry to say that the contractors are looting money from the government by systematically abusing the arbitration procedure. I have to say now, reliefs are being granted by the arbitrators, which a court would have refrained under the given circumstances. We have to understand that the private parties are very diligent in appointing arbitrators based on their background. There are awards being passed against government wherein the claims awarded are so enormous that it is making the contract economically unfeasible, thereby causing further loss to the public exchequer. Sir, under the existing Section 34 of the Arbitration and Conciliation Act 1996, the court has powers only to set aside an erroneous, patently illegal award and remit it back to the arbitral tribunal for de novo hearing. The powers of altering, modification, reversing the award, including powers of reappreciating the evidence, should also be provided under Section 34 to the court to prevent abuse of arbitral proceedings. Sir, such exorbitant awards are not just affecting administrative efficiency, but also causing great losses to the public sector undertaking and the government. There is a need to keep a check on the quality awards passed by the arbitral tribunals involving government contracts as they deal with public money and also act as an impediment to the development works carried by the government. The tendency of certain public sector undertakings having arbitrators panel and appointing arbitrators from that panel should also be avoided. A law can be brought to that effect. Instead, independent arbitrators can be sought from the arbitration centers. The fees of arbitrators should be regulated and should be reasonable. Conducting arbitration in five-star hotel should be avoided to make arbitration cheaper and make all persons to have access to arbitration. These things have to be followed. Sir, in order to project India as an arbitration hub, a sense of assurance is needed to be inculcated among the parties by providing them with a remedy against such arbitrary awards, which may threaten their existence itself. Granting powers for modification, reappreciation of evidence and alteration of the award to the court under Section 34 would lead to development of such jurisprudence which would act as a guardrail against such offending arbitral awards. My suggestion is that if an amendment to Section 34 is not possible, then please remove arbitration clauses from all the government and public sector contracts as it creates havoc. Sir, the Legal Services Authority should have a list of panel of arbitrators who are ready to do arbitrations free of cost and make available to all litigants who are interested in the arbitration so that the doors of arbitration will be open to the poor litigants. Honorable Law Minister should consider this. Sir, what our country needs is a robust arbitration regime. Mere changing the name would not do the job. We have to rehaul the Arbitration Act so as to achieve the real intention of the Act, sir. Thank you very much, sir.
Thank you. Honorable Shri Sushil Kumar Gupta ji.
मुझे इस महत्वपूर्ण बिल पे बोलने का मौका दिया